Hello and welcome to Raider HQ After Dark. I'm your host, Raider, and I'm just going to summarize this video as me talking about private DBQs and private companies that do medical assessments for you um, and do a medical evidentiary review on your behalf. Now, I've talked about this topic a little bit. I've also talked about potentially training individuals and organizations who conduct these particular evidentiary reviews on your behalf. Now, why do I think, in my infinite Raider wisdom, that they could benefit from having somebody train them as to the legal requirement? Well, the reason why I think that is because there is a lot of hubris involved in some of these companies. I have actually provided guidance. I've reviewed their medical opinions. I've reviewed their DBQs. Like, some people send me in redacted copies of it and say, hey, does this look okay? And I'm like, okay, well, as long as I don't know who you are and I don't know any of your PII, that's fine. Like, as long as you redact everything to where I can't even tell if you're male, female, or whatever, then that's fine for me personally, ethically, because there's no way to coerce me, right? So I look at it and I'm like, no, this is wrong right here. This specific language that keeps getting used by these companies and by these individuals is completely wrong, and it gets thrown out instantly. It doesn't pass the authenticity and credibility and sufficiency examinations. Like, there's multiple assessments that are done on private DBQs. So today somebody sent me in something that was specifically reported by the Raider. They actually went through and explained the reason why. And it's the same reason that I have. It's one of many. Like, there's many different issues that keeps getting repeated by these companies. So when the veteran goes back and says, hey, look, this is wrong, the company has the audacity to say, well, we've been doing this for a lot of years, and we know how the laws and regulations work with the VA. So the person that you talk to is wrong. Yeah. Yeah. So they've got their head so far up their fourth point of contact, and I'm not going to dox the company and I'm not going to dox whoever did it, but I'm just going to say, I'll provide you some receipts as to what it is. I'm going to help out. This is me doing it for free. Okay. Actually, I'm helping out the veteran because I'm going to point out to you specifically one specific thing. Now, this doesn't fix everything. This is just one thing in a multitude of things which can make your private DBQ insufficient. Okay. So let me go ahead. Let me just share my screen and we'll talk about it. So this is the heavily redacted rating decision in which they denied the veteran for sleep apnea secondary to asthma based upon the intermediate step for obesity. They're saying that their anxiety and depression caused their obesity and that their obesity caused their sleep apnea. Perfectly fine theory to use. It is granted on a daily basis. That theory makes sense as long as the evidence supports it, right? Now let's look at this for a second. Now I can't use my cursor on it because I just uploaded it as an image, like a background image. So we'll have to kind of read this together and you'll have to bear with me. And today's video is going to be a little bit shorter because this is just a filler video kind of thing. I'm going to do an actual video later on today, but I just wanted to put something out. So this says service connection may be established for a disability which occurred in service or is proximately due to or the result of a service-connected condition if the evidence shows that you have been medically diagnosed with a condition and there's a relationship between the claimed condition and the service-connected condition. Okay, so what is this? This is the blow-in text accompanied by 38 CFR 3.310 that tells me that this is the secondary portion. So whenever I review prior rating decisions and I determine what theories were applied to see if a theory was missed that could be applied, this is what I'm looking for. So I'm looking for 38 CFR 3.310 to show me that it's secondary. Cool. This is lining up perfectly. Although the evidence of record shows you are connected for generalized anxiety disorder, element 2, so they're conceding that element 2 is established. Um, and your VA examiner diagnosed you with sleep apnea during your exam on May 8th, 2025. This is satisfying element 1. So element 1 is satisfied. They opined it to be less likely as not proximately due to or the result of the service-connected condition. So you were denied for element 3. So that's how you would read this. I was denied for element 3. However, the rater took it upon themselves to take a jab at the private the person or organization who filled out the private DBQ. And so let's read this because I highlighted it because it's good. It might not seem like it's good. You might have already read forward and seen it, but I'll tell you why it's good. There is a private medical opinion indicating the OSA was directly due to or incurred during the time in service, and also stated the OSA was due to the anxiety with obesity as an intermediate step. Okay, so what does that mean? Well, that means that what I've seen on a daily basis from private DBQs is that the medical provider has this tendency to do a et al, like it's due to this and everything else, right? They misunderstand that when they do that, it muddies the water. So this particular private DBQ filler outer, what they decided to do was they said, yes, it's due to service, right? It happened in service. It's at least as likely as not that it was caused by service. So think about this from a chronological standpoint. Think about I was in service in 2001 to 2010, right? So the examiner is saying that OSA manifested between 2001 and 2010. Then, in the exact same medical opinion, they say that the OSA manifested after service because of weight gain, right? That's the logic that the rater applies. That's the logic that is broken by a lot of these companies, a lot of these individuals that are filling out the private DBQs. Now, I don't have a problem with them filling out the private DBQs, but I need them to understand that when they make a comment like this, when they say it's due to this and due to that, it can't be due to two separate things. Two separate things cannot inevitably cause it. They can contribute to it, they can exacerbate it, but they can't cause it. And that's the misunderstanding. And I'm doing this one for you can't do this. It causes a paradox. Okay? It causes a confliction paradox that both cannot be true. It's mutually exclusive. You can't say that both are true. It is equally true that it was caused in between 2001 and 2010, and it was also caused by 2016 whenever the veteran got fat. You can't do it. That's not the way the legal process works. Now, they got this back. Yeah. No. It doesn't work like this, guys. So I am doing this video to inform them but help you. Because you have to think the way you don't have to. Let me back that up. You should. You can choose to if you want to. You can think the way that I think. But this is the reality of the circumstance. If you do a private DBQ and the examiner muddies the water and says it's due to this and it's due to that, even offhandedly, it's at least likely as not that the veterans is due to them being overweight and service. Saying something just as benign as that splits their medical opinion into two different timelines. It's either, okay, so now you're making the rater have to look and see, okay, do these timelines match up? Because what could happen is if the weight gain was demonstrated in service, then this would be fine, right? Because both are true. It has to do with truth here. It has to do with the facts lining up. If the veteran both could be true if the veteran had their obesity in service. If they didn't have their obesity in service, which was not the case in this case, then it breaks the process. The DBQ, well, maybe not the DBQ, but the medical opinion that this is based on is now insufficient. It has a logical confliction with it. And this is the way that you guys, and I know this sucks, but you guys have to be auditing your own private DBQs and medical opinions for this logic. Because if you're not, and this is just one thing, guys, there are facets to this, like a prism, okay? Like there's just like different color schemes of things that you could do that are wrong. And it's not that the rater's looking to say no. It's that they can't say yes. If I was in a court of law, right, because this is a legal document, if I was in a court of law and they had to say, hey, look, are you confident that this is true? That you approved this rating decision, and this rating decision was accurate based upon the rules and regulations that you have to apply. I couldn't say yes, because you can't have something manifest in one time period and also be accused of having it also manifest in a separate time period. Which one is true? Because it changes things. It can even change things in terms of, like, sometimes when they do this, it breaks the effective dates. Because, like, let's say it could have first manifested before the PACT Act, and it's being, like, let's say it's being granted for Terra. Let's say it manifested after the PACT Act. Well, if the medical opinion sides with that it first manifested, or let's say the DBQ said it first manifested before the PACT Act, you can get a year earlier effective date based upon liberalizing law in Terra. But it just drives me up the wall, because these organizations think that they do things right. Because oftentimes what happens is they'll file, you'll do the evidentiary review with them. They'll examine you all on the up and up. They'll do a medical opinion. It gets thrown in the trash. Well, they send you to another examination, which indicates they threw it in the trash. Then you get granted. Well, guess who does the victory lap? They do, because they seem to think that they're it's just a happy accident that you became granted based upon the VA examiner's opinion, not based upon what you paid for to have them review and do effectively, right? This person you didn't pay gave you the positive medical opinion. The person that you went to for free gave you the positive medical opinion, not the people that you paid a lot of money to. So if, conditions may change, but standards should stay the same. This should not happen if you're paying for a, private medical opinion. This is a rookie mistake done by the largest and the smallest, the individual and the company. This is done so often that this note is rare. Like, oftentimes due to the short form narrative, the rater doesn't have to actually provide this. It's just, it boggles my mind. Okay. And once again, I'm sitting here drinking a coffee going, if I'm paying money for something, then I should have that, I should have the skill and expertise. I want to see skill and I want to see expertise. I want to see a resume. And just doing something, like, imagine somebody with a resume that says, hey, I've been doing this wrong for 10 years. Okay, I'm not going to go to you. Just because you've been doing something for a long time doesn't mean you're good at it. Doesn't mean you're doing it right either. So there are legal requirements. So I hope that I explain this to the veterans that are listening. I hope that I explain this to you effectively, so that way you can screen to make sure that it is not muddying the water with two separate theories for service connection, because the tie does not go to the veteran. Okay, the the tie goes to Confusion Town, and Confusion Town gets a new examination. Okay. So whatever this is, where I'm trying to hedge my bets on two different theories, there is no way to grant for two separate theories. The system will not allow it. You have to pick one theory, and we try to pick the most advantageous one, right? Like if two theories apply, then we do advantageous, but that has to do with presumption, right? Like presumption is the one where that scenario happens, not here. So the fact that they muddied the water with it occurred in service, but also is due to the intermediate step. They should have stopped that it incurred in service. And if there was evidence in the STRs, that would have been, no one would have blinked an eye at that. There is no reason. And it also comes to the, and I'm just hitting everything today, but it's like the VA process. Sometimes you can say more and it hurts you. This is a systemic problem with people who actually do the private DBQs as part of a job. You know, they professionally do it. This is a systemic problem for them, is they keep saying more than they need to say. Like I'll read a private medical opinion or DBQ and I'll get to a certain point. Okay. Nope. And there's a nope situation where nope, can't take it. They just kick themselves in the butt. And on, I think the video yesterday, I pointed out that if there's any kind of like incongruence with what the examiner says, like the veteran has a good gait, right? They have a normal gait. And then they come and say, the veteran walked in with a cane. It's that. That's what the rater's looking for. They're looking for inconsistencies. They have to find. Raters, over the years, it rewires your brain to where you contrast things. That's what the job of being a rater is contrasting things, looking for differences. Where are the differences? Where are the inconsistencies? That's all they're looking for. And some of the individuals, some of the companies, because I'm not going to say all, but, and I've only ever said one good thing about one private provider in a couple of my videos, and that's because I've adjudicated a couple of their DBQs and medical opinions, and they were solid. So but I've adjudicated a lot of others. Like there is a nurse practitioner group down in Florida that they just put out a cookie cutter thing, and they don't care because they got your money, no refunds. You know, I don't know. Be careful, guys. And if you're a company or an individual, you know, I meant what I said, that maybe in the future I will provide education about not how to game them to win, but definitely not how to snatch victory or snatch defeat from the jaws of victory. Right? If you have the evidence there and it's substantial and you should be granted, then you shouldn't be denied on a procedural issue. And that's what this is. Somebody just accidentally said the wrong words. And if they hadn't have said those wrong words, the veteran should have been granted instantly. And there should not have been another medical opinion. But anyway, guys, I've kind of rambled about this for way too long, 19 minutes. So, but anyway, I'd like to take the time, you know, if you like the content, I'm going to be doing more content about, you know, how things are rated and whatnot. And I'm going to address some of the theories for service connection that I haven't gotten to yet. So that's kind of what I'm moving forward with on the channel, with some of this sprinkled in here. So some of like just the systemic problems. I'm going to try to keep it to the big ticket items, and then I'd like to take the time to thank everybody that's liking and subscribing. If you're liking and subscribing, even if you're not liking my content and you're commenting, that's fine. And, you know, I take constructive criticism. You can ask people on the channel. I've changed things. I've changed a lot of things in order to hopefully make things better, make them more, receptive. But like I've said many times, I'm trying to work myself out of a job by teaching you guys how to at least be the most informed that you can be, so that way you don't have to pay for anything, or that way you don't get taken advantage of. And I don't know. But anyway, that's about all I got for you today. Raider out.